Coming up, the intersection of religion and the law.
Is there any reason to think these kinds of moral arguments would single out religious conscience as more important than other kinds of liberty of conscience?
University of Chicago Law School's Brian Leiter challenges the vaulted status of religion in the laws of the U.S. and other Western democracies. It's just ahead on Global Ethics Forum.
Our speaker is Brian Leiter. Professor Leiter is a Carl Llewellyn Professor of Jurisprudence and Director of the Center for Law, Philosophy, and Human Values at the University of Chicago. Professor Leiter will be discussing his new book, which is provocatively titled, Why Tolerate Religion?
Let's start with an example to make the issue concrete. So imagine it's the first day of middle school and a 13 or 14-year-old boy arrives at school for the new school year and he has his dagger strapped to his belt. Principal takes note, calls the police, says, we have a boy who's brought a weapon to school. And of course, weapons are prohibited in the school. It seems like a simple case should end right there, but it won't if in fact the boy is a member of the Sikh religion. In the Sikh religion, like many religions, cultural traditions, there are rites of passage that mark the arrival of manhood. In the Sikh religion, a boy at about the age of 13 or 14 acquires an obligation to carry what's called a kirpan, which is a ceremonial dagger. However, I want to emphasize many of these ceremonial daggers are actual daggers. That is, they're real knives. In many jurisdictions, Sikhs have challenged the law that prohibits the carrying of the kirpan in the schools. And in many cases, including in the United States, in a major case in Canada, in the Canadian Supreme Court about 5 years ago, they held that the Sikh child does have the right to carry the kirpan in the schools, notwithstanding the ban on weapons in the schools. This is sort of a concrete example of what's being required. The law, needless to say, disapproves of the carrying of weapons in the schools, but the state is then asked to tolerate an exception to that rule so that an individual can discharge their religious obligations of conscience. But now imagine a slightly different case. Not a wholly fanciful case. I taught for many years at the University of Texas. There are families who have spent generations working farms and ranches in parts of both eastern and especially western Texas. And one might imagine in such a family that they too had a certain kind of tradition to mark the passage to manhood, namely that when a boy was 13 or 14, he received from his father a knife that the father had received from his own father, who had in turn received it from his father, and so on, going back a century. And he's expected to carry it with him because a knife turns out to be rather useful on a farm in all kinds of contexts. If that boy, however, shows up on the first day of school with that knife on his belt, he's not going to get an exemption. He can argue that this is very important, it's central to the traditions of our family, I feel I must do this, it would disrespect my parents and my grandparents were I not to do it. He's going to be out of luck. He will not get an exemption from the law. And this is the puzzle that I think is presented by the law of religious liberty, not only in the United States, but in other Western democracies, which is that we grant exemptions, not always, but sometimes we grant exemptions from laws of general applicability to people who claim that it conflicts with their obligations of religious conscience. But if somebody claims an obligation of conscience that's not religious in character, they end up having no standing to ask for a similar kind of exemption. So my question is there a good moral reason for thinking that religious claims of conscience are more important than other claims of conscience, such that only they should be entitled to exemptions from the law? I canvass in my book two lines of argument that have been prominent in the modern philosophical tradition. One I associate with the great American political philosopher John Rawls from his 1971 book, A Theory of Justice, and the other with the great English utilitarian philosopher John Stuart Mill. And let me just briefly describe those arguments. Rawls says, look, if you want to understand what justice is, what justice would require in a society, we need to undertake a certain kind of thought experiment. And the thought experiment goes like this. He says, imagine we are something he calls the original position. That is a position where we're going to choose the foundational principles that will govern our society. And we want these principles, right, to be fair and just principles. In order to ensure that they are, he says we have to make a decision about these principles behind what he calls a veil of ignorance. Right? And the idea of the veil of ignorance is that in choosing the principles of justice, you don't know your own place in the society in which you might find yourself. So you are stripped of the knowledge whether you will be rich or poor, white or black, Christian or Jewish, and so on. You simply don't know. And the thought here, the intuitive thought is that genuine principles of justice will be impartial in a way. Right? The idea of the veil of ignorance is to sort of wash out the self-interested considerations that might corrupt people's judgment about what society would be like. And Rawls's conclusion is that in such a situation, one of the principles of justice that people would settle upon would require a broad scope for liberty of conscience. And he's quite specific, it's liberty of conscience, not just liberty of religious conscience. One thing people do know in Rawls's thought experiment of the original position, they do know that they will have a conscience. That is, they know that they will be people who have a sense of right and wrong, of what must be done, about what's obligatory, and so on. And on the assumption that people are a bit risk-averse, which is an important assumption Rawls makes, if you know you'll have a conscience, but you don't know whether you'll be in the dominant group in a society, it'll be very important to protect liberty of conscience so that there is a sphere in which you can still act on your sense of right and wrong, even if it turns out that the dominant groups in society don't share your view about that. That's the Rawlsian argument. It derives broadly from what's called the deontological tradition in moral philosophy associated with Immanuel Kant. The emphasis is on the rights that individuals have, in this case, a right to the liberty of conscience. Now, interestingly, John Stuart Mill in the utilitarian tradition, which is often thought to be this conflicting tradition with the deontological tradition, Mill also arrives at a very similar conclusion. The utilitarians think, look, what's right and wrong, what's morally right and wrong, depends on what would maximize utility or happiness in society. Right? And Mill thinks, famously, that discovering the truth will maximize utility. And this is quite important to his argument for liberty of conscience. He says, if we discover what's true, if we come to true beliefs, not just true beliefs about the natural world, true scientific beliefs, but also true beliefs about the best ways of life, which he thinks we can arrive at, we'll all be better off. Right? Now, why does that require a certain scope for not just liberty of conscience, but also liberty of speech, freedom of association, and other familiar kinds of liberties? Mill's thought goes something like this. He says, look, let's suppose we were already in the possession of the truth. Right? But Mill is also a fallibilist. That is, he thinks we can never be absolutely certain. So even though we think we know what's true, we might be wrong, and we have to be aware of that. Well, we'll never figure out we're wrong if other people can't contradict us, if other people can't express different kinds of views. All right? So we may think we know what's true, but we could be wrong. If others can't express contrary views, we're unlikely to figure it out. But even if it turns out we think we know what's true and we're right, it's still useful to have people expressing contrary views because we will then be clearer about the reasons why we believe what we believe. We won't just, as it were, hold it dogmatically. We'll understand the reasons for why we hold our beliefs because they're subject to challenge by other people. But Mill goes one step further than this, and this is an important fact about John Stuart Mill, which is he thinks that there are better and worse answers to the questions, how should we live? How ought we to live? Mill famously says, many of you may have heard this slogan, he says, better to be Socrates dissatisfied than a pig satisfied. But now how do we know? How do we know what the qualitative differences are between kinds of happiness? And Mill says we know, right, by virtue of asking people who've had experiences of different kinds, different ways of living. So strictly speaking, someone would have to know what it's like to be Socrates and what it's like to be a pig in the mud. Nobody really knows that. But secondarily, of course, we can see the evidence of different kinds of life that people live in order to get an informed view of which kinds of life really are conducive to happiness. So Mill says we need a wide scope for what he calls experiments in living. There has to be room in a society for people to experiment with different kinds of life to provide us the evidence for assessing which kinds of life are better and worse than other kinds of lives. So Mill, like Rawls, though for different reasons, ends up with the conclusion that we need, in fact, a fairly wide scope of liberty of conscience, of free expression, but also to experiment with different ways of living. But of course there are limits. Right? Of course there are limits. And in Mill's famous formulation, the limit comes from what he calls the harm principle. The harm principle has been very influential in Anglo-American law. The harm principle basically says, it's captured in a saying I'm sure you're all familiar with, my freedom to swing my fist ends at your nose. Right? That is, the limit to my freedom is that I can't cause harm to other people. Physical harms present clear-cut cases. Psychological harms present slightly harder cases. It's crucial, though, for Mill that a harm that doesn't count is simply that other people are offended by thinking that other people are doing things they disapprove of. Right? So in the battles, for example, in England over the decriminalization of homosexual sodomy in the 1960s, the argument that prevailed was basically a Millian harm principle argument. That is, the argument was people having consensual homosexual relations don't harm anyone. The fact that it offends some people who disapprove of homosexuality is not a reason for the law to, in fact, criminalize the conduct. So the harm principle sets a certain kind of limit on these arguments for liberty of conscience and liberty of speech. And Rawls actually accepts something very close to that, but I won't go into the details about that. So there's two kinds of moral arguments for why we ought to think liberty of conscience is important. Is there any reason given these arguments? And I rely on these arguments because they have a fairly wide intuitive resonance. They actually are manifest in our law and policy, the underlying intuitions in different ways. Is there any reason to think these kinds of moral arguments would single out religious conscience as more important than other kinds of liberty of conscience? And to that end, I have to take up the question, what's distinctive of religious conscience? Okay? What makes a claim of religious conscience different than other kinds of claims of conscience? So I focus on different aspects of what seems to me distinctive of religious claims of conscience. And I identify three. So the first, which is characteristic of all claims of conscience, is what I refer to in the book as categoricity of demands. That is, it is characteristic of all religions that they make certain categorical demands on their adherents. There are certain things they absolutely must do that are not optional. And of course, if they didn't do that, they wouldn't come into conflict with the law. Right? It's precisely because the religion says you must carry the ceremonial dagger with you once you are a boy at the age of 14 in the Sikh religion that a problem arises when the law says you can't bring that dagger with you into school. But all claims of conscience, all demands of conscience, whether religious or otherwise, have this characteristic that they impose categorical demands. Right? When we say we feel as a matter of conscience we have to do something, we're saying we must do it. It's not going to be negotiable. Okay? Second characteristic of religion, and now this one is more distinctive of religious claims of conscience than some others, is that all religions are characterized by certain kinds of beliefs that are insulated from ordinary standards of reasons and evidence. And by ordinary standards of reason and evidence, I mean the standards we use in ordinary life, which are actually continuous with the standards that are employed in the sciences. And what I'm trying to capture here is the intuitive idea that in all religions there are certain beliefs people accept on faith, as it's often put. Right? Third characteristic of religions, I suggest, is that all religions, in some way or another, try to provide what I call existential consolation. By existential consolation, I mean roughly this. Not to spoil your evening, but the fact is everyone in this room will die one day. We will all endure loss, pain, suffering, misfortune, and all religions in one way or another try to help their adherents understand and deal with these facts about the existential situation of human beings. And of course, the existential consolation function of religions is one of the reasons why religions, of course, are so important to people, because these facts of human life are universal. So if what's characteristic of religious claims of conscience is that they involve this conjunction of categorical demands, insulations from reasons and evidence, and a certain kind of existential consolation function. Is there a reason to think that liberty of religious conscience is more important from either the Rawlsian or the Millian perspective than other kinds of claims of conscience? And I argue that there is not. But be clear about what I'm arguing. I'm arguing that there are reasons to tolerate religious claims of conscience, but those are the reasons for tolerating liberty of conscience. Generally, they're not specific to religion. If the reasons for religious liberty are not specific to religion, right, what should we do with the law? Right? There seem to be two pretty obvious possibilities. First possibility would be to create a scheme of what I call universal exemptions for claims of conscience. Now, I guarantee no legal system will adopt this approach. First of all, it would be almost tantamount to legalizing anarchy, because it would mean, in effect, that every single law actually operates as follows. You'll have a legal obligation to do X unless you have a very good conscientious reason not to do it. And if we open the door, of course, to that possibility, then the courts would be overwhelmed with legal challenges to laws based on claims of conscience, and courts would be put into the very difficult position of having to adjudicate whether these claims of conscience were actually genuine claims of conscience. But it's not just worrisome as a practical matter. It seems to me it also raises a different kind of concern. Because when we grant exemptions from laws of general applicability, sometimes we frustrate the purpose of those laws. And if those laws are just and fair laws, if they, as I say in the book, if they really promote the general welfare in some plausible sense, then granting exemptions sometimes frustrates the efforts of the law to promote the general welfare. Here's a very tangible example and a very live issue in certain parts of the United States right now, not so much in New York or Illinois, fortunately, but certainly in California and Washington and the West Coast, laws requiring mandatory vaccinations of children. In every state, you can get a religious exemption from complying with the mandatory vaccination law. In some states, you can actually get what they call a philosophical exemption, though it's not quite clear what they mean by philosophical, and there doesn't seem to be a lot of oversight of this. But this is a case where the exemptions are what I call burden-shifting exemptions. That is, if you exempt certain people from mandatory vaccination laws, you actually create risks and shift burdens onto other people in the population, which is, of course, what we're seeing now in the West Coast of the United States, where we see outbreaks of whooping cough, measles, diseases that would have been eliminated by mandatory vaccination schemes. It seems to me mandatory vaccination schemes do promote the general welfare, and when you grant exemptions for reasons of conscience, religious, or otherwise, you are shifting burdens onto other people in society in a way that is fundamentally unfair. And so the other approach would be what I refer to as the no exemptions approach, which says if the law is generally neutral and it promotes the general welfare, then there should be no exemptions given to it, right? If those exemptions would shift burdens onto other people. And I want to emphasize that because sometimes exemptions from the law are not burden shifting, and it seems to me in those cases, exemptions probably should be given for legitimate conscientious objections. So a very simple example that'll be familiar to everyone who's ever had a driver's license, right? The rules governing driver's licenses always require your photograph to be taken without any headgear, right? But why not give an exemption to the Sikh man who must wear his turban or the Orthodox Jew who must wear his skull cap to that law? It doesn't shift burdens on anyone, it doesn't defeat the purpose of law, and it allows the individuals to discharge their religious obligations. That's an example of a non-burden shifting exemption. But with respect to laws, exemptions that would shift burdens, it seems to me that it's fundamentally unfair, right, to the rest of society to grant exemptions to those laws for conscientious objections. And let me just conclude by mentioning that this view I'm describing, the no exemptions approach, is roughly the view that the United States Supreme Court adopted in 1990 in an opinion by Justice Antonin Scalia. This was a case called Employment Division versus Smith. Mr. Smith was a member of a Native American religion that required its adherents to use peyote, which was an illegal narcotic. He got in trouble for using peyote as part of his congregation, and he lost his job. He was fired. Okay? He then filed for unemployment benefits and was denied them on the grounds that you were not eligible for unemployment benefits if you lost your job because of use of an illegal narcotic. And that's what he challenged in a case that went up to the United States Supreme Court. And what Justice Scalia essentially said is very close to what I described as the no exemptions approach. He said a general law of neutral applicability, right, such as laws prohibiting the use of certain illegal narcotics, the state doesn't have to create exemptions from those laws just because people have religious objections to them. So Mr. Smith was out of luck. Now, as I said, this was the position the United States Supreme Court adopted. It is not today the law of the land. As my research assistant said, Congress and the states adopted a scorched earth policy towards employment division versus Smith. There was a terrible reaction to it. Prior to Smith, right, it was much easier for someone with a religious objection to a law to get an exemption. Many states, probably all of them at this point, interpreted their state constitutions as providing exemptions from laws of general applicability if they burdened people who had religious objections to them. The federal government, this went through several iterations, but in the end the federal government adopted a rule that basically constrained the federal government not to enforce federal laws that would unnecessarily burden the free exercise of religion. Right? So even though the official interpretation of the First Amendment of the United States Constitution, according to the U.S. Supreme Court, is what I'm calling the no exemptions approach, in practice it has almost no bite at this point. But of course, whether that will change in the future is something that remains to be seen.
Would you consider atheism to be a religion?
Given the characterization I have given of religion, atheism would not, in fact, be a religion. Now, there would be protection for atheist conscience that falls under the scope of liberty of conscience. But I take it what's characteristic of atheism is that its beliefs are not presented, at least some of its central beliefs are not presented as insulated from reasons and evidence. Now, I'm going to add a little caveat to that. I think there are some the new atheists, as they're called, the late Christopher Hitchens, Richard Dawkins, Sam Harris, people like that. And people often chide them and say, well, they're as bad as, the fundamentalist religious types. And I think the reason they say that is partly that sometimes those folks almost do argue as though everything they say is insulated from reasons and evidence. And that seems to me a mistake. But I don't see that there's any reason one has to go that way. I think the new atheists make one other kind of mistake. They make the mistake that thinking just because some religious beliefs are false in their view, right, therefore they're no good, right? And I take the view, because I also study the German philosopher Nietzsche, and I think he had a very important insight when he said that illusion and falsehood is essential to life. And that the fact that something we believe is false is not necessarily a fatal objection to it. I like to give the following example. Some of you may be familiar with this psychological study which showed that the only people who have a correct perception of how others perceive them are the clinically depressed. Right? That, in other words, most of us carry on in part, when we are not in the grips, as hopefully we are not, of clinical depression, carry on based on false beliefs about what other people think of us. Right? There's a very tangible sense in which a certain kind of illusion is clearly essential to functioning life. So I do think it's a mistake in this debate to think that the truth or falsity of beliefs is the entire issue. One might well think certain beliefs are false, but there are still very powerful reasons to tolerate them under the scope of liberty of conscience.
Christian Science believes that they can cure illnesses, and some parents have a child and they don't allow them to go to doctors or do anything like that. And it seems to me that question as to when the law should step in and for humane reasons comes into play, and I'd like you to talk to that question.
Good. Okay, so this And of course, there are many real cases like this, right? Notice the case is complicated by one thing, which is that we are talking now about the welfare of children, right? Who, in most matters, their welfare is within the scope of parental authority, but there are exceptions, right? That is, we have laws that I think promote the general welfare, that are meant to protect the health, safety, and well-being of children, right? On that grounds, of course, parents can even lose custody sometimes of their children. It seems to me that laws that protect the health, safety, and well-being of children, including laws that mandate that they receive certain kinds of life-saving medical treatments, are laws that are neutral, that serve a general purpose of promoting the general welfare, and that parents should not, in those cases, have the right to exempt their children from life-saving medical care, and perhaps even less serious forms of medical care as well. The harder questions here, well, a different kind of question is, well, what about the adult adherent of Christian Science or another religion that wants to refuse certain kinds of life-saving medical procedures, say a blood transfusion, which again is another issue that arises. It seems to me harder issues because in general we do, while suicide is illegal, we do recognize that at the age of majority, individuals are entitled to a great deal of autonomy in managing their own affairs, including when they do so very badly. The question is whether this crosses a particular threshold. I'm not sure what I think about that, but I think the child case is much easier. I think the laws that protect the welfare of children are sound, well-justified laws, and there should not be exemptions from them for any kind of claims of conscience, religious or otherwise.
I'd like to thank Professor Leiter for taking the time because it was a fascinating discussion.
Thank you very much.
So much.
For more on this program and other Carnegie Ethics Studio productions, visit carnegiecouncil.org. There you can find video highlights, transcripts, audio recordings, and other multimedia resources on global ethics. This program is made possible by the Carnegie Ethics Studio and viewers like you.